Hello again, everyone. It's Rob Ryder on Saturday, October 18th, 2014. And did you know that you must appear for an ordinance violation? Must appear. At least in Illinois. Don't have a choice. If it's an ordinance violation, you must appear. Well, then what would happen if you didn't appear for an ordinance violation? That would be called failure to appear. Wow, now we're into something that they may come and serve you with a warrant. So you must appear. And, we're going to discuss what exactly that means, and this is just one of a number of things that some I'm going to kind of just blow through and say we're going to talk about this in the next video, because there's just no way I can do it all in the same video. But this concept here by itself is utmost importance, so please pay attention. So I was looking around these local court rules and general orders. So I found these. I don't know how we eventually. Rose sent it to me numerous times, but when I just want to go find them online, I just type in Kane County local court rules, and I see this link that I've hit a number of times. It comes on that leads to this page here, and this is what it is. Right, most of these local court rules are online to download as PDFs. Some of them, as you can see, aren't. But I did find eventually could find a PDF that had all these local court rules on it and didn't really need to use this for that anymore. However, at the time, by going through this, many little lights go on. So for instance, again, and this is before we even talk about must appear, in Article 18 under probate proceedings, which is this right here, it says in the very first line, the following rules are adopted as rules of the Circuit Court of Kane County, Illinois, applicable to proceedings in probate, chancery, eminent domain, administrative review, miscellaneous remedies. Right? Now this said the Circuit Court of Kane County, Illinois. If we go back and look at this, this says 16th Judicial Circuit, Kane County, Illinois. Well, that and Circuit Court of Kane County, Illinois are two different courts. Right? So these rules are, from here on out, everything applies to proceedings in probate, chancery, eminent domain, administrative review, miscellaneous remedies. And they're all heard in the same court, Circuit Court of Kane County, Illinois. So what court are they referring to? Well, it's in the probate division. And judge means judge or associate judge assigned to the probate division. Can hear cases having to do with probate, chancery, eminent domain, administrative review, miscellaneous remedies. Motion includes every petition, application, or other matter requiring the entry of an order. So if when they tell you to motion for something, they're not necessarily call it a motion. It's a petition. A motion is if you petition, apply, or you motion to get an order. They're all called motions. But you're not giving him a motion, you're giving him a petition. And it would go to the Circuit Court of Kane County, Illinois, which, see, now they don't have a probate division, although they don't come right out and say it. So now this is where, once you find something like this, you just go put in Illinois Probate Division into Google and see if you can find another county's website that gives more pieces of the puzzle and takes you further and further. Long story short, we're going to do a whole video on this, but this is just to show you, and I'm going to show you evidence that there are two different jurisdictions right now. All right, this is called a probate packet, and it's for the same circuit court, judicial circuit that for Kane County, except this is DeKalb County because the circuit encompasses more than one county. The 16th Judicial Circuit's like three counties. It's Kane, DeKalb, and another one. Well, it said on the first page. Kane, Kendall, and DeKalb are all under the 16th Judicial Circuit. All right. And so at the top of the page, the Circuit Court for the 16th Judicial Circuit, DeKalb County, Illinois. Circuit Court for the 16th Judicial Circuit, DeKalb County, Illinois. Next one, same thing, DeKalb County, Illinois, right? So far they're all the same court, same court. So without any further ado, we'll just go to the end and we'll see, well, here's one that says in the Circuit Court for DeKalb County, Illinois, Probate Division. This is going to a different court than this one is, in the Circuit Court for the 16th Judicial Circuit, DeKalb County, Illinois. That's going to one court. That's going to the 16th Judicial Circuit. This one's going to the Circuit Court for DeKalb County, but you're going to give the paperwork to the same person, called the Circuit Court Clerk or the Circuit Clerk. Depends what hat they have on. So there's two different jurisdictions, and the one we need to be going to is in the Circuit Court of DeKalb County or Kane County or whatever the county, the Probate Division, but it may not be called Probate Division, so we need to know what Probate Division means, and so blah 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 blah. Nevertheless, well, there you go, right? In the Circuit Court for the 16th Judicial Circuit, DeKalb County, Illinois. It's a different court. Okay, and see, a long time ago, it seems like a long time, year and a half, 2 years ago, Roe had been told by the Circuit Court Clerk, right, the clerk of the court for her county, Kane County, Thomas, we just call him Thomas anymore, I don't remember his last name to be quite honest. Thomas had said to him, circuit means county. Well, if that's the case, this would say then in the county court of DeKalb County, Illinois, Probate Division. Excellent. Now we're talking county courts. And you go look in Blackstone's time in county courts, right? Way back when, this just ties in all the things we already talked about, the earl and the bishop sat together in the county court. And they heard all cases. 1070 AD, Norman invasion, King Edward I, I think it is, he came over. First order was, we're going to take the bishop out of the county court and give him his own court. And and now just the earl will sit over here. But basically what he ended up doing was giving the county court to the Jews because he put them in charge of all the counties, because they were the king's property. That was the contract they had with them, and eventually led to the Magna Carta, which is just another contract with the Jews, between the kings of England and the Jews. I mean, go look up baron. Just go follow the definition of baron back. You'll see baron leads to noble, or noble leads to baron. I don't remember which way it is. Whatever one they use in the Magna Carta, take that word, find the definition. It'll take you to the other definition, and it will tell you that that definition, be it noble or baron, I don't remember which one, is the definition of a Jewish magistrate. Go figure. Fear the Jew. Martin Luther said so. All right, who's the Antichrist? The Jew is. He's the one who doesn't believe that Christ is king, that Christ is God. He has to be the Antichrist. So, anywho, here we go. So, another video will be on the Circuit Court of Kane County, but that isn't really what we're here for today. That's what I'm saying. There's just so much to talk about. We're going to talk about the ordinance violation because it doesn't have a damn thing to do with either of these courts. That's the thing. The ordinance violation happened in a jurisdiction that uses ordinances. It doesn't use numbers or state laws. It uses ordinances. All right, so anyways, at the bottom of this thing, it had the county circuit clerk's office, attorney information, and customer service sheet, and that's kind of hard to look at, so we're going to look at something a little bigger, which is this one. And it has many, many things on there, and I'm just going to point out the ones I saw that are of interest, right? Send orders for judge's signature. Again, we'll get to the thing about must appear, but all this stuff is just too good not to point out. The circuit clerk's office does not hand orders up to the judge that are sent in the mail. If you need a judge to send a judge an order, then you must mail it to the courthouse where the judge currently presides and address it to that specific judge's attention. You don't put it in the court file, you mail it to the judge and you send him an order. So let's say you want an order of protection. Well, according to this, that's an order. I would send it to the judge. I need you to sign this order, judge. I need an order of protection. You would tell them why, put it all in there, and send it to them. But what they want you to do instead is they want you to go to this room 149 to the judge's secretary to blah, 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 right? To get you out of the jurisdiction you want to be in, where you should have just sent the damn thing to the judge in the first place. Then the judge you would send it to is the judge, the circuit court judge for the county. That's who I'd send it to. I want his order from the county. So back to the county. So anyways, they split them up, and then the county, it just has jurisdiction over, it's the sheriff's court, and it has, and they have jurisdiction over cases with a value of less than 40 shillings. All right, a couple of bucks. It is the small claims court, not the one that says small claims, the county court, because it doesn't give money damages. What it does is it's really supposed to be there doing the same as the King's superior courts, one of those being the Court of Chancery. It's supposed to be giving you justice locally, what should be happening. But it's the county court that does that. It's where it's the one that has the ecclesiastic office built into it, because it's the one who can determine who guardians ad litem are. And so really that's what we're talking about. Who determines, who picks the guardians, says they're the guardian? That's probably the court. And it's not the probate court necessarily, because the probate court is the administrative end of the probate court. The probate court doesn't necessarily call itself the probate court. But the court that calls itself the probate court is the administrative part of a court that's going to handle the probate stuff. But there's, as we saw, there's things in chancery, there's miscellaneous remedies, there's all these other things that we should be using the court for. Body attachment, writ or warrant. Did you know that an arrest warrant is actually a term for admiralty court? All right. Courts of law, they hand out bench warrants, not arrest warrants. Which again, that's just evidence that they're using admiralty law locally, and they can do that in the state courts under the Savings and Suitors Clause. I'll be doing a video about that shortly. But okay, enough of this. So anyways, there was a number of interesting things. For instance, all civil new cases must be accompanied by a new case information sheet. Now, when we had gone down to put a case in, they gave us a civil action cover sheet, not a new case information sheet. And I already, I closed that thing up, didn't I? Here, we'll look real quick. See, new case probate information sheet. That's what it should call it. New case, I don't know if probate should be in there, but I guess it could. So I'd say new case chancery court information sheet. I don't know. But it's not civil action cover sheet, which is what you get when you go to open a civil action and pay the $170, whatever they charge, or $400 at the federal court. So, you know, you just learn to question everything you read. If they're not doing it, this is to me is their procedures, and if they're not doing it by the procedure, I want to know why. So, new case cover sheet. Tell them that's what you want for your court case, or new case information sheet. But where are we? Must appear cases. Any offense that is marked as a must appear offense requires a court appearance. The circuit clerk may not accept a plea or payment on these prior to the judge's court order assessing fines and costs. Examples of must appear are traffic citations with personal injury, driving 26 and over, school bus zone, no insurance if proof isn't shown, and all ordinance violations. If the ticket issued by the officer is a mandatory court appearance designated by the statutes, even though the officer marked an incorrect box on the ticket, you must still appear before the court. If they didn't mark it that you have to, but it's one of these things here, you still have to show up. You know, if they made a mistake, it's your fault for not showing up. And now, so one of them is no insurance if proof isn't shown. And I guarantee you, at least I won't guarantee, I have to believe that when they ask you for the paperwork at the window that whatever you're giving them for your insurance isn't proof of insurance. And so in every case, it'd be like an ordinance violation, right? No insurance, you have to appear. That's what it seemed like. Ordinance violation cases. Once a case has been filed with the court, it is a must appear case. And again, it isn't even saying what court. It's just saying in the court. Well, what court? How about an administrative court? How about? The clerk's office cannot assist in the matter. Our office cannot accept a plea nor process payment in these cases until it's been assessed the fine. So until a fine has been assessed by a judge, there's nothing the clerk can do. Right? So going to the clerk isn't going to be the answer. If the case involves animal control, you may contact animal control with questions you have. You have to appear to provide the judge with proof of vaccination, justification you no longer have the pet. Okay, well, what judge? Right? If you have, if your case involves animal control, you're supposed to call animal control. Well, is that where the judge is? Could be, right? This is we're going to find out. Now, here's another biggie: consolidated court files. When the Kane County Circuit Clerk's Office receives a court order to consolidate 2 or more files, our office will put the files into a brown folder with one case number being the lead case. Let's stop right there. So where does the court order come from? Well, we just saw if you want to have an order, you mail it to the judge to have him sign it. You create the court order. So you could create a court order. Somebody could. Right? To combine 2 or more cases into one case, giving all the cases just one number, right? They're all going to have the same number. Let's read on. The lead case will be the number on the outside of the folder. Whichever case number the order depicts as being the lead is the only case number which is to be used for all future documents. The 2 cases have become one at this point. The subordinate case number is now closed on our system since it is being consolidated into the new lead case. No documents should be filed in the subordinate case number. All issues will now be heard and entered under the lead case number. They're going to take 2 cases, get rid of one number, give them both the same number, and run 2 cases at one time under the same number. Well, how can they do that? Well, because somebody put an order in. But that's what they wanted to do. And it will be in a brown folder, which is very interesting because Roe's case is in a brown folder. And another thing we're not going to get into today, but we are going to, is the record retention book that specifically says what's supposed to be in a file, what's supposed to be in a record. And one of the things is a miscellaneous case should have a light red folder cover. Hers has got a brown cover. And this says there's more than one case consolidated. So we're going to get into that stuff right there. But here you go, right? Must appear case. I didn't make it up. They said it. All ordinance violations. Jeepers. You better make sure you haven't been charged with an ordinance violation. Right? But how would you know? How would you know? Well, we're going to find out here in just a second. So hang on a second. Let me go switch. Okay. February 1941, right? If you want to check this out for yourself, pause, write this down, and you can download it yourself. They're not hard to find. Just put in prosecution under state law and municipal ordinances as double jeopardy. Charles M. Kneier. Kneier. As much as you think you need to. And I'm not going to read this. We've already talked about this in the earlier video, right? I'm just going to show you that this is the way the law looks at it, or those who say that they're enforcing the law. Prosecution under both state and federal law for the same act does not constitute double jeopardy. A person so prosecuted is not placed in double jeopardy since he is being tried in 2 jurisdictions for an offense against different sovereignties. A distinction is thus drawn between the offense of a law and an act offenses against the law and the act constituting the offense. Following this principle, may a person be prosecuted under both municipal ordinance, all right, so ordinances are municipal, and state law, which is usually the statute numbers and that kind of stuff, to the same act. Does the act, in this case, constitute two offenses? Well, jeepers, they've decided that yes, it does. Right? Or is the city in such case acting as an agent for the state, and would prosecution of violation of both ordinance and state law constitute double jeopardy, being prosecuted twice by the state? Right? Are you being prosecuted twice, double jeopardy, or have they found a way to work around it? Let's see. Well, in the states which hold that a city may be constitutionally authorized to punish an act, even though it is also an offense under state law, the view taken is that the test for double jeopardy is not whether the defendant has already been tried for the same act, but whether he has been put in jeopardy for the same offense. Give it two different numbers and it's the same act that you can be tried for that really mean the same thing. Right? So you can be tried in two different jurisdictions. That's really what they're saying. And that's what this whole thing here was about. And, that's enough on that. So, yeah, they believe that they can. So here's the original complaint for Roe. And this goes back to her going into the county clerk's or the county recorder's office and questioning why she was being charged $40-some for something that should cost $6. And next thing you know, right, they're calling the police and they're going to file a complaint against her. I guess she got too close to the truth. And we see that they mark the box next to the people of the state of Illinois. Before we go any further, we should understand that the people of the state of Illinois is not the state of Illinois. This is easy enough for you to convince yourself. Go to your state court of claims and go look at the entity that would be the respondent to a claim to the court of claims. And in Illinois, it would be the state of Illinois, or the name of one of its subparts, like the Department of Transportation, Secretary of State, whatever, something like that. But it's not the people of the state of Illinois. That is not the name of the sovereign entity, and the sovereign entity has to sue and be sued in its own name. That's why it's called a sui juris legal personality. So the people of the state of Illinois is not the state government. It's a it may be a municipal corporation, but it's not the de jure state government. It's no different than a city or village. So, all that to say, when they did this thing, they took her state ID, which has her name as Rosita Strauss-Caveen, and instead put down Strauss-Caveen, Rosita. And they gave her the wrong zip code. Her zip code is 60174, not 60175. And so, if they were to ever mail or something, it probably would never get to her because it would go to the wrong zip code. And this is supposed to be a copy of a complaint. A complaint that had been apparently notarized by a notary with his official seal of a notary. But wait, they crossed out notice to appear. No, you don't need to appear. No, don't appear, don't appear, don't appear. Whap, 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 whap. Huh, that's funny. Maybe for the state she didn't have to appear, if that's what this is for, because this is just a complaint. All right, so here's a complaint. Sandy Wegman is the county recorder. Right, so it wasn't the government bringing the charge, it was a private citizen, Sandy Wegman, and she put her address as being the frickin' address of the building she works in. Complainant's address. Well, that's not her address. Right? If the defendant's address is where she lives, then the complainant's address is where they live. So what was the alleged charge? Disorderly conduct. The alleged offense, right? Disorderly conduct. So there's one offense. And what's another one? 720 ILCS 526-1A1. If you go read that, guess what that is? That's disorderly conduct. Right? But these are two different jurisdictions. One uses the words, one uses numbers. It's like on your checks. Right? Where dollars, the word dollars is, that's a weight in gold and silver. That's one jurisdiction. And where they have the peso sign in front of the box where you put in numbers, that's another jurisdiction. That's the legal tender jurisdiction. Disorderly conduct written out is the jurisdiction of the ordinance, excuse me, and the other one is the state. So this same complaint then, right, this complaint, as we'll see, could be sent to two different jurisdictions, and one jurisdiction may decide not to prosecute, but the other one does. Now that's all great if it had been done properly, but I did a video about notaries here not too long ago, and right, this isn't done properly. And the reason it isn't done properly is it doesn't have the jurisdiction that a notary is supposed to have on their paperwork. And so again, before we get into, unfortunately, you'll enjoy this stuff. This is all good stuff. But before we can get into why you must appear, which, you know, we're just going to zip through it this week, because we had seen this and we decided to complain about it to anybody we could. Right? Complain. Who can we take our complaint to? Without getting into the people that didn't answer, because I'll do a video on that, this whole thing by itself. What did happen was we sent a complaint, sworn complaint, on the 22nd. Complainant states on oath it is her belief, knowledge that the attached alleged oath of office of one of the judges, associate judge, and of the Circuit Court for the 16th Judicial Circuit of Illinois is fraudulent instrument filed in the office of the Secretary of State. The alleged notarial act on her act on Judith M. Brokaw is not in conformity with Illinois statute, lacking proper seal and official title. In its present form, Judith M. Brokaw is claiming to be Chief Judge of the Supreme Court. And she is. Let's look at her oath. Why don't we? Because, you know, we can. Oh, we'll look at that one too, but that's not the one I want to look at. This is the judge, Elizabeth K. Flood. That's, you know, the judge over the case that Roe has been charged with, whatever she's been charged with, criminal. Should have been disorderly conduct, but we'll find out what it is. All right, here's her oath of office. I, Elizabeth K. Flood, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Illinois, and I will faithfully discharge duties of the Associate Judge in the Circuit Court for the 16th Judicial Circuit. Blah, 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 blah. Well, one of the things I didn't know at the time, but now I do, and I'm looking at this. This was filed in February, and they pick the judges. The judges take office the 1st of July, according to the Supreme Court rules. But on this thing, she's calling herself a declarant. If you look up the definition of a declarant, that means an unsworn statement. A declaration is an unsworn statement. And the undersigned, now this is, you know, so it's being witnessed by this Judith M. Brokaw, who says she's the chief judge. Well, the chief judge of what? Because all this has on there is that it's from the Supreme Court. And she's not the judge of the Supreme Court. In Illinois, if you're doing a notarial act, or act of a notary, which this is, because you're verifying somebody's oath, you have to put your official seal. And there's no seal on here. That's because it was unsworn. This lady's a declarant, right? So she didn't have an oath. Also, Judith M. Brokaw, the chief judge, isn't a notary in the county. Let's look at Judith's. December 22nd, 2008. I wonder if that's, you know, we'd have to go look and see how she was, if she was appointed, elected, how she got her office. Got a whole thing to do on election office. This is all great stuff too. Now look at, upon receipt of executed oath of office, the declarant, again, a declarant is not sworn to be placed on the payroll of the judicial branch. Right? Well, that's on that oath, and on this one it's been covered up. Okay, so here's somebody scribbles. We don't know who it is. We don't know what their title is. We don't know what office they're holding. We don't know any of these things. Right? It's a declarant. Just go look at the definition of declarant. Right? You declare to an unsworn declaration. So they ain't swear to anything. It's not an oath of office. They ain't take an oath. Well, we didn't point all that out, but we went on to point out blah, 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 blah. So Judith M. Brokaw is not qualified to perform notarial act. She is not registered in the with the county clerk of the county of Kane. I don't want to read this whole thing, so why don't you just stop, pause, read, and continue. All right. So, anyways, what we were doing was we were pointing out certain things in the book. And pointed out this gen number 1317026. That is Sandy's complaint. All right, we're pointing out that this guy here didn't do it right. Now, the reason he didn't do it right is because one of the elements that's missing is what's the jurisdiction. That's a requirement. What's the jurisdiction? And the jurisdiction is that little part where it says state of with a line and county of with a line. That isn't on here. There's right where it's not determining what the jurisdiction is that this was done in. So, okay, so right, so we're pointing out that this is color law, simulated legal process. Blah 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 blah. Okay. Now, where does that leave us? Well, we got two judges' oaths. One that's this one, who just declared, right, didn't take an oath, is performing the act of a notary on another one who didn't do anything. And so neither of these are actually oaths of office, and it's a simulated document. You know, if the requirement is to swear to it, they didn't swear to it. Now, where did all that leave us? Okay, so Roe did her complaint, and see, this is what the jurat is supposed to look like. And I'm of the opinion now, because they have these jurat and affiant statements, every state does, that you don't write your own on the bottom. You have them go get it and attach it to it. So if it was really short, you could just write it in this block here, but they can't do it. So here's the jurisdiction part: state of and county of. Now this guy put IL for the state, right? So if that's the jurisdiction he's in, you're not supposed to use any abbreviations. That should be Illinois. Everything should be spelled out. Nevertheless, right? That's what's missing on these oaths. So it can't be the act of a notary because it's not on here. So they didn't swear to it. And a notary is the one you swear to. You don't swear to a judge, right? A judge can take your testimony, your oath, or so forth because they hold the office of notary that comes with their office. But they still have to do it by the notarial act. And the act says this kind of shit's important. State of, county of. You got to have it on there. You got to put your official seal. Right? These things had to be on there. So, you know, Roe got this put on her complaint, and then she went down to the county and got a certificate of authority. Again, there it is, state of Illinois, county of Kane, right? That's the jurisdiction. Now this one's got problems because it says right here, not valid unless a embossed county seal, Kane County seal, is affixed. Now, what does affixed mean? Does that mean impressed in there, or something that's stuck on there? I think they're supposed to put the gold leaf on there and then impress it, emboss it, because this certificate of authority is invalid because it doesn't read the way that it reads in the Notary Act. In the Notary Act, it says in here that this thing has full faith and credit as a public record. And finally, now I understand what the difference is between a private and a public record, and it's this. if you go and record something and they give you the original back, it's a private record. If you go and record something and they keep it and give you a certificate back, it's a public record. Right? Public records are records that they produce and they keep the original. Private records are when you keep the original. That's the difference. You haven't created. If you have the original of something, even though it's got the notary seal, everything done, it's a private record. It wasn't. Well, there's no evidence that it was a public record. Now, how can you get it to be a public record from the notary? And I think it's this simple. You ask them for the page, a copy of the page that they put it in their book, because that is what it says it's your right to have a copy of. Why else would you need it except to prove it was a public record? So I'd get that and staple it to this, and there's your public record. But I think what they do is like they at the title company and so forth, because they're doing all sorts of notary work. That's where I got my notary work done. A lot of people go to banks. I would go to the title company. They said that, yeah, we have to do it. So, okay, excellent. So a lot of times when you're looking at people's foreclosure paperwork, you see these like registration numbers or something that have been written on the frickin' document. And I think that if you were to file that back to the notary, that goes to their book, and that's the entry in their book, and that's what made it a public record, the fact that it has that frickin' number on there. Or if you were to get a copy of the page it was put on and make it part of your document, that it would serve the same purpose. But you have the right to ask the notary for a copy of the entry that they put into their book, or if they have a receipt, or whatever else it is. So anyways, this is an invalid certificate of authority. It's another simulated legal process. Okay, but all that being said, nevertheless, what happened out of that? Well, Roe sent it to Office of the Executive Inspector General. Right? That's as it turns out, in Illinois, they like their inspector generals. In fact, the city of Chicago has an inspector general. But the Office of Executive, well, who's the executive? That would be the governor. Office of Governor's Inspector General. I like the word executive better than governor, but I'll take it. So we sent it to them because they have jurisdiction over misconduct of public officials. So we're not claiming that these judges are judges. We're claiming they did the act of a notary, and it's official misconduct of a notary to do it wrong. They're not responsible for what you put on the paper, but they're damn sure responsible for what they put on the paper. So this said, well, here to start with, they took her complaint that you saw and they put a number on it. It's got a complaint number. Outstanding. And this was on October 8th, so it took about 2 weeks to get a complaint number. I think it was the 22nd, we'd said. Office of Executive Inspector General for the agencies, the Illinois Governor, received your September 26, 2014 letter complaint. We will review the information and determine what course of action, if any, should be taken. We may open an investigation or refer this matter to another agency or law enforcement authority to take appropriate action. Please be advised that our agency is required to keep confidential all records and information pertaining to any investigation we undertake, including the identity of the complainant. Therefore, we will be unable to provide you with the status or outcome of any investigation we may undertake, although under certain circumstances our final investigative reports and findings of misconduct may be publicly released. Well, it should be a public record, right? I should be able to go do a FOIA on this complaint through that company or through the agency and find out anything that went to it. If you made this complaint on behalf of an agency or board, state of a university or regional transit board, please revise the findings of this complaint do not obviate any other obligation. If you have additional information concerning your initial complaint or any other matter, please feel free to contact us, and I think that's what we're going to do. Your commitment to ensure honesty, integrity, and accountability in state government is greatly appreciated, and we thank you for bringing this matter to our attention. And they did all that in lowercase. That's just wonderful, man. That's like the basic stuff. Right? So I have to go back and listen to things I was pointing out on these because, yeah, they want us to tell them more. Well, I got more to tell you about why these people, because they're declarants. They never swore to their oath. They never swore an oath. And they weren't elected. We're going to do a video on elections yet, on local elections. Nobody's been elected. And we finally pushed them in a corner because we found in Illinois where it says what you're supposed to do is you're supposed to go to your local election precinct, which might be like a 2-mile by 3-mile block. School district, one school. If you had a school, one school, how many people would that draw? How big of a territory would they give? Right? Because I live in a township, 6x6 township, and it had to have 5 or 6 district schools, so they each be a school district within this 6x6 area, the one-room schoolhouse. Right? That size there is the elemental republic, the size of a township, organized town, also known as a political, an election precinct. And so you're supposed to be able to go to this election precinct and fill out an affidavit to become a qualified elector. And we kept sending this to the county clerk there, and they finally said, to get a hold of this election committee for the state and tell them, ask them about becoming a deputy registrar. And when you go look up what that means, maybe you need a deputy registrar to register the people in the precinct. And they don't have one, so you need to become one. And they can make all committee men deputy registrars. So the first thing they're going to do is make you a committee man in your election precinct, and you just became an elected officer in the state, and that's going to change your status. That's all great stuff. Man, there's just so much to talk about. It's wonderful. But moving on, right? So anyways, hey, we finally got somebody to respond. I mean, this is the whole reason for sending things, is to try to get somebody to say something. And the Office of Executive Inspector General, thank you very much. I don't know what you told us, if anything, but hey, you wrote us a nice letter. It's more than we normally get. And we do have more to tell you, Ricardo Meza. Absolutely. He's the Executive Inspector General by, right? This all looks like it's been done properly. I don't know if it should have a seal on it or not. Probably should. Where's your seal? Can we say that's the seal at the top? I don't know. Anyways, that was, that's a sidebar of just things that have been happening. So, all of this based on the same thing that we're talking about now. Guess what? It's an ordinance violation. It was all ordinance violation. So give me just 1 second again. Okay, we're back to must appear, ordinance violation. Saturday, October 18th, 2014. We're going to get in the meat of it now. But before we do, hey, can you donate, please, so I can eat? I can't pay my rent. 15th of the month, 16th, whatever it is. Need some help? Please help. Please, 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 so I can eat. PayPal to Ashley Rytlewski, ASHLEYRYTLEWSKI @gmail.com. Just pause the damn computer for a second, write it down, and please send something, or send it in the mail. Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. Okay? You writing it down? Alright. Just pause it and finish up. And when you come back, this is where we're going to be, right here. Talking about this. Kane County Code. So all these local municipality, less than state, whatever they are going to have some kind of code. If it's a organized or incorporated city, right, the city could have a code. This code for Kane County applies to all unincorporated areas of the county. So they say. Let's see what it says. They got, right, so this is just one section of the code, and this is on administrative adjudication. The County of Kane hereby adopts Division 541 of the Illinois Counties Code as amended, 55 Illinois Compiled Statute, blah, 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 blah. So all this is saying is Kane County is only going to take one piece out of this. If you were to go look at 55 ILCS 5/541, I think, and start there, it gives this whole public act that really covers the same things we're talking about now, but there's a few counties that wanted to write theirs slightly different, so they have. Okay, so out of that, all I can tell you is there's certain parts they're saying that come out of this code, and this code has to do with administrative adjudication in municipalities, basically. But procedures not exclusive. Not limited to relief in the circuit court for the 16th Judicial Circuit, Kane County, Illinois. Right, so this administrative office, if they can't get what they want through their administrative adjudication, they can bring the claim to the circuit court for the 16th Judicial Circuit, Kane County, Illinois. Circuit Court for the 16th Judicial Circuit, Kane County, Illinois. All right, so this is the complaint. This is saying if it's an ordinance violation, that this 16th Judicial Circuit, Kane County, Illinois, is the court they're going to go to, and this is written to the circuit court for the 16th Judicial Circuit, Kane County, Illinois. Okay. In this article, unless context reviews otherwise, code. All right, so these are definitions, right? So any ordinance that pertains to or regulates any of the following: animal control, the definition, identification, and abatement of public nuisances, right? The definition, identification, and abatement of public nuisance. So the definition of a public nuisance. I have to laugh, right? Because that's what they did here. What they charged Roe with is the definition of disorderly conduct. Knowingly and intentionally alarm and distress Sandy Wegman in as much as unreasonable manner as to alarm and disturb Wegman and provoke the breach of the peace. That's the definition of disorderly conduct. Right? She's been charged with a definition. Code enforcement officer, a county employee authorized to issue citations for county code violations, to conduct inspections of public and private real property to determine whether the code violations exist. However, nothing shall be construed to allow for administrative adjudication of an ordinance violation in the case when the state statute or administrative rule provides for specific method of procedure to be followed, other than administrative adjudication in enforcing county ordinance. All right, so that's all they can do. Is just, it sounds like what they're saying is all we can do is administrative adjudication, and then we have to take it to the circuit court. All right, and they got some county employee that's going to be the code enforcement officer. Hearing officer, a person other than the code enforcement officer or law enforcement officer, who is appointed by the chairman of the county board with the consent of the board to preside over administrative hearings. There you are. First test. Who's the hearing officer for administrative hearings under the county code? Every hearing officer must be an attorney licensed and practiced law in the state of Illinois for at least 3 years prior to conducting administrative adjudication proceedings. Hearing officer shall have successfully completed a formal training program that includes the following. Yeah, what this really sounds like is somebody who's involved in arbitration. So there going to be instruction on the rules, procedures for administrative hearings, orientation of subject area, the code violations they will adjudicate, observation of administrative hearings, participation in hypothetical cases, property owner, respondent, solid waste, just more definitions. So here we go. How does this thing work? There's hereby established a code hearing unit in the county government. The code hearing unit shall consist of a hearing officer an administrative assistant, and a recording secretary. The function of the code hearing unit shall be to expedite the prosecution and correction of violations of county ordinances, regulating animal control, the definition, identification, and abatement of public nuisances. So again, we're going to define what a public nuisance is, and we're going to enforce it. Charges of code violations are to be heard and adjudicated by the hearing officer appointed by the Kane County Board Chairman with the consent of the county board. So now we know it's the Kane County Board Chairman who's appointed, who's ever going to be hearing and adjudicating ordinance violations. So when we saw before that it says you have to appear for an ordinance violation, it sounds like this is the guy you need to appear before, the guy that's over the administrative hearing. Who is he? Here's his duties: to preside at an administrative hearing called to determine whether a code violation exists, to hear testimony and accept evidence from code enforcement officer, the respondent, I guess you need to show up, and all interested parties relevant to existence of code violations, to preserve and authenticate the record of the hearing and all exhibits to so that he has all the testimony of the hearing, to issue and sign written findings and decisions, to issue subpoenas, to impose penalties. Dang, it sounds a lot like a judge. Well, what's the procedure for doing this? When a code enforcement officer observes a code violation, the officer shall note, or in the case of animal control violation, the code enforcement officer may respond to the filing of a formal complaint by noting the violation on a violation notice and report form. So the officer shall, when a code enforcement officer observes a code violation, right, so he would see it, shall note, or in the case of animal violation, the code enforcement officer may respond to filing of a complaint by noting the violation on a violation notice and report form. Well, they're considering you an animal, right? And somebody's put in a formal complaint about your behavior, about your animal's behavior. But anyways, they're supposed to put it on a thing called a violation on a violation notice and report form. So we're looking, now we want to find out what a violation notice and report form is. Indicating the following: the name and address of the respondent. If known, the name and address, the vehicle registration number, blah, 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 blah. The violation notice and report form shall contain the file number and the hearing date noted by the code enforcement officer in spaces provided for that purpose on the form. So I don't know if that has anything to do with this number up here, gen number 13-17026. See, and they're not charging Rosita, they're charging Stroskavine, Rosita. Who the hell is that, right? That's not Ro. Must be her animal. The violation notice report form shall state the failure to appear at the hearing on the date indicated may result in determination of liability for the cited violation. Oh, there you go. You didn't appear, and they're going to tell you on the form. Right? But on this form, they crossed out notice to appear. It's because this form is being used by two different jurisdictions apparently, and the one jurisdiction that's using the numbers, the state said, you don't need to appear, but this complaint went to the complaint officer, code enforcement officer, who's moved it ahead. That's different, because now if you don't appear to their hearing, they're going to send it to the 16th Judicial Circuit, Kane County, Illinois Court, where really what you're going to be charged for is failure to appear. And so the ordinance violation is still hanging out over. You're in contempt of court in one court. Okay. The violation notice and report form shall state the failure to appear. Got that. The violation notice and report form shall state, shall, love the word shall, right? So when you find this thing, you're going to see, shall state, that upon a determination of liability and the exhaustion or failure to exhaust procedures for judicial review, any unpaid fines or costs imposed will construe a debt due and owed to the county. So if you don't appear and you don't exhaust your remedies, you're going to owe the frickin' bill. The code enforcement officer shall certify the correctness of the information required by subsection A of this form by signing his name to the violation notice and report form and indicate the date on which it was done. Failure to certify does not invalidate the violation notice, but will not establish prima facie case at trial. How much you want to bet they didn't sign it? The code enforcement officer, right? Because they're supposed to take this complaint information, and they're supposed to generate this other form they called the what the hell they call it now, the violation notice and report form, and then they're supposed to sign it, right? And they're taking this and they're going to give it to the hearing officer. Well, them not certifying it doesn't invalidate the notice. It just isn't going to be prima facie evidence at the trial. So a copy of the violation notice and report form shall be filed with the code hearing unit and served upon the respondent either personally or by first class mail, postage prepaid, sent to the address of the respondent. Well, jeepers, this isn't Rose's address, right? That's not her name. It's not Stroskavine Rosita. Her name's Rosita Stroskavine Staskuvine. Sorry, Roski. And that's not her zip code. 60175 is not her zip code. So she's never going to get the notice. And when she was arrested, right, this is what they gave her. I don't know if they gave her this, even if they gave her the complaint. I don't think they gave her the complaint. They gave her this other piece of paper. I didn't even know this stuff existed. She went and bitched about it, and they threw a few more pieces in the file. But what we learned since then is, you know, this whole thing about the records is you don't ask for the docket sheet. You ask for what it's called for in their procedures. It could be the record sheet. And it could be a thing called the basic record that has all the documents that are supposed to be in the file. And it could be there isn't even a paper file, that it's all done electronically. And if you don't ask for it to be put on the list, you're not going to get the notice that anything's been added to the case. The fact that there's paper doesn't mean anything. It's an electronic file. That's why they do it in federal court. Since 2006 in Arizona, they haven't had any paper files. They've all been electronic. No matter how much paper you see laying around, the real file is in the computer. And it isn't paper until you print it out. Now, I don't know if that's how it works in the state, but it's not far from being the same. Right here, they could have given it to her, but they didn't. They're going to mail it. They're going to mail it to the wrong address. You're not going to get it. Guess what? You're not going to appear. If the name of the respondent's property owner cannot be asserted, or if the service on the respondent cannot be made by mail, service may be made on the respondent property owner by posting not less than 20 days before the hearing is scheduled a copy of the violation notice and report form in a prominent place on the property where the violation was found. Well, in Rose's case, the place where the violation was found was was in a county building. And so somewhere, behind the plant, they got a frickin' bulletin board and they stick this thing on there and you know it's there. I mean, this is easy enough for them to get around. They're not going to mail it to you. They're going to say, well, we posted it on the bulletin board. So again, where do they post these things? Ask them. Where do you guys post the violation notice report form? In a prominent place. Notice a hearing. The respondent, no, you got 20 days to respond. Well, okay, now we're just into normal court stuff. All administrative hearings shall be conducted on the date of the hearing. At a time prior to the hearing date, or at the request of code enforcement officer, the attorney for the county, the respondent, or the attorney of the respondent, the hearing officer assigned to the case, may issue subpoenas directly witnesses to appear and give testimony at the hearing. If at the time Set for hearing, the respondent or his attorney fails to appear, the hearing officer shall proceed with the hearing and accept evidence relating to the existence of a code violation. Right? So now they're going to hand them the form, even though it's not prima facie evidence. They're still going to say it's evidence. It's hearsay evidence. Still evidence. Even though it doesn't have the guy's signature on it, because you weren't there to rebut the fact that, hey, his signature isn't on the form. At the close of the hearing, upon sufficient evidence, hearing officer may enter a default judgment. Go figure. A copy of the order of default served promptly in any manner of service a notice violation prevented in this article. And applicable to the violation, a copy of the default judgment, which is a final determination, shall apprise the respondent of the procedure for setting aside the default judgment, and also apprise the respondent of the availability of an appeal to the defendant's judgment to the Circuit Court of Kane County. See, now this is the other court. Appeal of the default judgment to the Circuit Court of Kane County. Is that the 16th Judicial Circuit, or is it the Circuit Court of Kane County, as we saw earlier? A respondent against whom a default judgment has been entered may file a motion with the Code Enforcement Unit to set aside the default judgment and for a new hearing. File a motion with the Code Enforcement Unit to set aside the default judgment for a new hearing. Representation at the hearing. The case for the county may be presented by the Code Enforcement Officer or by the state's attorney. In no event, however, shall the case for the county be presented by an employee of the Code Hearing Unit. The hearing officer shall preside over the hearing, shall hear testimony, shall accept any evidence relevant to the existence or non-existence of a code violation on the property indicated. Right? So they're calling, well, there you go, right? They're calling this here, this is strictly property. Stoskavine Rosita is property. The Code Enforcement Officer signed violation notice report form shall be prima facie evidence of the existence of a code violation described in the form. Did he sign it? The strict rules of evidence applicable to judicial procedures do not apply to hearing authorized under this article. Right? So they can take hearsay evidence. The burden of proof is a preponderance of the evidence. It's by the pound. Once a prima facie case is established by the county, the burden of proof then shifts to the respondent. Okay, well, how do they establish a prima facie case? The code officer has to sign the frickin' form. And whether he has or not, it's okay, right? But you need to go for the ordinance violation. I don't have it now, but we did. I showed before in Batavia, Illinois, a city that has its own code. In there, it gives the fines for these different ordinance violations, and for disorderly conduct, it's a $25 fine. Right? Go pay the fine, be done with it. Instead, they're going to try to throw her in jail. I mean, they're trying all sorts of crazy ass stuff, man. Find these determinations in order. At the conclusion of the hearing officer shall make a determination on the basis of evidence presented at the hearing as to whether a code violation exists. The determination shall be in writing and shall be designated as the hearing officer's findings, decisions, in the order. So the counties, well, though, right? The question is, who is this administrative hearing officer talking about? Is it the judge that's sitting as the circuit court for Kane County judge? Or is it some attorney in the, is it in a court that we don't know is a court? Because we're really talking about administrative hearings. Administrative hearings aren't any different than arbitration hearings. Okay, administrative review. The finding, decision, orders of the hearing officer shall be subject to review in the Circuit Court of Kane County. So, if it isn't the judge of the Circuit Court of Kane County, it could be the associate judge, who's basically fulfilling the position of a magistrate. They used to have magistrates. They got rid of them, and the last time they did their constitution, they came up with associate judges, appointed for 4 years, the same a magistrate was before. I'm just going to call them a different name. Right? So I'm going to say that's who they're talking about. The administrative review law and rules adopted pursuant thereto shall apply and govern every action for the judicial review. Right? So if you went and looked at the administrative review law and rules adopted pursuant thereto, so what rules have they adopted based on the administrative review law? It's going to tell you how they're going to govern this judicial review. Transfer or conveyance of property. In order to correct code violation and sanctions imposed by county against a respondent property owner as a result of a finding of a code violation under the article shall attach to the property, subject to interest of all lien holders of record, as well as the owner of the property, so that the owner cannot avoid finding a code violation against the owner by conveying or transferring the property to another. In other words, this is how they're keeping you from owning your property, is because there was a code violation in the past that's never been cleared up, and you haven't taken care of it. Well, they're not going to let the conveyance of the property go through. Any subsequent transfer or owner of property takes the property subject to the findings, decisions, and order of the hearing officer. Under this article, if a notice consisting of a copy of the order to correct a code violation and imposing any sanctions and cost, if applicable, and a description of the real estate affected, that is sufficient to identify the real estate, has been filed in the office of the Kane County Recorder by the county prior to the transfer or conveyance to the subsequent transferee or owner. So you need to go to the Kane County Recorder and ask them if they got a copy of an order to correct a code violation against your property. Right? Check your notice index for code violations against my property. Or go to the office where all this paperwork's going in and ask them if they got it. Any fine or other sanction or cost imposed, or any part of a fine or other sanction or cost imposed, remaining unpaid after exhaustion or failure to exhaust procedure for judicial review under administrative review law is a debt due and owed to Kane County, and as such may be collected in accordance with applicable law. Any subsequent owner or transferee of property takes subject to this debt if a notice has been filed pursuant to section 2330 of this chapter. And this is against your real estate we're talking about, right? If there's a claim against the real estate that was done through this administrative hearing as an ordinance violation, and you haven't appeared to take care of the ordinance violation, then the violation still exists against the property. You're the owner. You need to go take care of it. After expiration of the period for which judicial review under the administrative review may be sought to final determination of code violation, the county may commence a proceeding in the circuit court for Kane County for purposes of obtaining a judgment on the hearing officer's findings. Whatever that means. Upon commencement of the action, the court shall file a certified copy of the findings, decision, and order, which shall be accompanied by a certification that recites facts sufficient to show that the findings, decisions, orders were issued in accordance with the Article 55 of this thing here, which basically all this 5-541 points out is what the duties of the administrative hearing officer are. Yeah. So, I mean, it could be anything from you're growing weeds in your yard, right? They can call grass weeds. You got weeds growing in your yard. They put an ordinance violation against you. It may never have been prosecuted. It may never have been signed. It may never, right? Nobody's put their name to it. It was put in there. It's not prima facie evidence. It's just hearsay evidence. But you've never rebutted it. You've never appeared. Because of an ordinance violation, you must appear. You are incorrect. Get your ass down there and take care of your paperwork. Service of summons, copy of the petition may be any method, right? They could mail it to you, right? They could use the wrong address and say they mailed it to you. The court is satisfied with the findings. The court shall render a judgment. The court may issue other orders or injunctions or both requested by county to enforce the order of the hearing officer or to correct a code violation. Okay, so that's about it for the law. Now, it's just something on Aurora's hearing officer. All right, so Aurora is a city, and they talk about, at least in one part, about having this hearing officer. The hearing officer is an attorney whom we hire to pay close attention to property maintenance issues and to get to the bottom of them. Employing a hearing officer results in the case being settled faster, Anderson said, adding that the cities such as Peoria, St. Charles, Oak Park, Springfield, and Evanston have observed Aurora's success and have adopted what Aurora has done to settle property maintenance and zoning violation matters. In cases where property owners do not fully comply, fines are imposed. Right? So you need to go to whatever code you're in. If you're in a city that has a code, go find that officer and take your property. Take your name, take everything. You want to know what's against your name and against your property. Aurora's hearing officer also hears animal control, parking ticket violation cases, dealing with impoundment of vehicles whose owners I have violated. Right? So this is the dude, right? Here's the dude. Animal control, parking ticket. Well, he's also doing property. And when they say animal control, they're talking about your animal, right? You live in an animal. God gave you an animal. You're a mortal living spirit inside that animal. And when the spirit isn't acting properly, then you just act like an animal. Okay, that's why you got to go there, right? That's why we're doing this. What else was there? Just real quick. Message from the state attorney's office. The first priority of the state attorney's office is to represent the interests of our community, which includes your family and the people of Illinois in criminal proceedings. Right? They're supposed to represent the interest of our community. That includes you, your family, and people of Illinois in criminal proceedings. So, in a criminal proceeding properly done, if you took the complaint to the state's attorney's office, then it should be prosecuted ex rel. State of Illinois ex rel Robert Allen Rutluski versus whoever it is you're bringing the complaint against. And they should prosecute for you. Right? This is lowercase people of Illinois. This isn't proper. Right? And here it's uppercase people of state of Illinois. Well, it ain't the same as the people of Illinois. Right? They don't make a mistake. The people of Illinois is the people of Illinois, which is you, if you live in Illinois. Okay. The men and women of the state's attorney's office have dedicated themselves to this duty, whether it's an attorney in our criminal division prosecuting a violent criminal, a counselor in our diversion program providing rehabilitative services to non-violent criminal, a counselor to a non-violent offender, or an attorney in our civil division collecting unpaid child support. Making sure that our children of King County is a safe, healthy place. Blah, 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 blah. Blah, blah, blah. Okay. I hope you find, so where is the stuff I want to get to? As the state attorney, it's my job to make people pay for the crimes they commit. But it's everybody's job as a community and society to ensure the crime does not occur in the first place. If we really want to solve our criminal problem, we must stand together in one clear, strong voice and tell the criminal element they do not have safe haven on the streets of Kane County. I thank you for the opportunity to serve this great county. Thanks, Joe. So, Joe, why don't you get yourself a big-ass crucifix and some holy water and start scaring them frickin' satanic, devil-worshipping pagans out of the building? Because the people that we come see are the problem, and they're working for you. Who do we bring our complaint to, Joe? Tried to bring one to your office, wouldn't let us do it. And Joe was appointed Kane County State Attorney. That's interesting, because Kane County State Attorney's Office. The Kane County State Attorney's Office employs 138 staffers, 58 assistant attorneys, 80 administrative. The state's attorney is elected by the citizens of Kane County. I just thought you said he was appointed. Joe was appointed Kane County State's Attorney. So the state's attorney is elected by the citizens of Kane County. So who is the state's attorney? And is it only elected by the citizens of Kane County, or is it elected by all citizens of all counties? Is the state's attorney the governor? He's the chief executive, and the attorney is just under the executive branch. Right? And Kane County's state's attorney is that the same? Because you were appointed, Joe, and the state's attorney's elected. I don't understand. Somebody's got to explain that to me. I know that appointed means elected, right? It's just a different way of being elected. Different group did the electing, and they're going to call it an appointment, but a group got together and said, "You're our man." They elected you. What do? The state's attorney's office is mandated by the Illinois Constitution to represent the people of Illinois in the prosecution of criminal cases and to represent county government and state officials within Kane County in civil matters. All right, so but the main one thing I want to get to on here was this right here. How do I get an order of protection? And we were talking about the orders of protection before, and it said to mail it to the judge to get an order of protection. Now this says on his site, if you choose to get an order of protection, you must appear in court at the Kane County State Attorney's Office. Right? The Kane County State Attorney's Office at the Aurora branch, the Kane County State Attorney's Office at another one in Elgin. But either way, you must appear in court at their office. Right? It didn't say to go to the court in this building. It said go to the Kane County State's Attorney's Office. That's where the court is. That's where the court is to get a protection order. Okay, well anyways, there you go. What did all that mean? Well, it means if you can donate so I can eat, I would certainly appreciate it. But what it means is a declarant means you didn't swear to anything, and so this isn't an oath of office, and we have more to tell the Executive Inspector General, Office of the Executive Inspector General, a few more things about these pieces of paper. Right, this complaint was used for two different jurisdictions, one being the word jurisdiction, the ordinance, and the other one being a statute jurisdiction, the state. And apparently they've been merged together under one court case number that's in a brown folder that, because of what it is, as being charged as a misdemeanor, should be in a red folder, and it isn't. And this notary committed official misconduct because he put a seal to a document that is not formatted properly to be a properly certified notarial act. And the notary is not responsible for what you say on the paper, but he's definitely, he or she, for what they do on the paper. They don't do it right, it's notary misconduct. And so, now Roe sent one. They had another office called the Secretary of State Police force for the Secretary of State, and some sergeant wrote back and said, it doesn't appear that there's anything wrong with this, right? So we're going to send that to we're going to send his answer to the Inspector General. Well, thanks, Inspector General, because this sergeant says he didn't see anything wrong with it. Now I got to tell Roe, well, a sergeant isn't a commissioned officer. That's why he's a sergeant. He's not an officer. We need to somehow get it back to somebody to say, hey, we don't want this sergeant's opinion, right? I want an officer's opinion. I want a frickin' seal on the paperwork. And then 2 days later, she got this answer from the Inspector General's office. So we'll just deal with them. Now, I sent one to an office called the Office of the Great Seal here in Michigan, pointing out what was wrong on some oaths and bonds for officials down in Bratch County. And I haven't heard anything yet, but I have some hope now because, Roe just got something. And we did them about the same time, so I'm going to keep checking the mailbox. But even though they did all this crap here on this thing, right? I mean, they crossed it all out. It was a complaint. This complaint went 2 different places. One place, apparently, was done as an ordinance violation, and it possibly could have been continued as a disorderly conduct in an administrative hearing that we didn't really know was going on. You don't show up, they didn't send you the paperwork, or they did send you the paperwork and it went to the wrong address, and then they are going to go prosecute you in this court, in the circuit court for the 16th Judicial Circuit, Kane County, Illinois, for failure to appear. You're in contempt of court. And until you appear, because it's a must appear as far as ordinances are concerned, it's a must appear. You have to go to the administrative court. I don't see how I can get around it. That's what we're going to find out. We're going to go find this administrative hearing officer and see what he can tell us. And there was one other thing, just because I'm talking now and I want to have said it and be done with it. This thing right here. This is the other piece of paper that they gave Roe. Certificate of defendant in the circuit court for 16th Judicial Circuit, Kane County, Illinois. Right before, when they first picked her up, this is the piece of paper they gave her, if I'm not mistaken. Right? They weren't going to let her leave until she put an X and signed the paperwork. And what she's involved in is a Class C misdemeanor, which should be $120 cash bail. And see where it says bond type? They should have put a check right here. They didn't. They put it down as a 10% of a bond. So she never paid her bail. Right? What's she supposed to do? Now, offense, D.C. You can't do that, right? You got to write the shit out. But it says in here, in the certificate of defendant, which is the, this is the juicy part. Where's that? I, the undersigned defendant, do hereby acknowledge myself to be indebted to the people of Illinois. Right? Capital P, people of Illinois. Proper case, people of Illinois. A particular people of Illinois. Not lowercase people of Illinois, meaning everybody. No, this is a particular group. People of Illinois. Or the city or village set forth as a municipal corporation in the sum indicated as bail. Right? Basically, she just signed a piece of paper that says she owes somebody, a municipal corporation called the People of Illinois, $1,200. And that's what they're coming to collect, this $1,200 bill. Well, so, and there was other pieces of paper involved in this too, but this is the only piece of paper they gave her when she left jail, was this one here, right? She didn't get anything about the complaint. And so the complaint's gone to a hearing officer who didn't sign anything but filled out a form and sent it to the, not to the hearing officer, went to the enforcement officer, code enforcement officer, who filled out a form, probably without signing it, and gave it to the hearing officer, who held a hearing on the day you didn't show up. Said, yeah, you're not here. Well, I guess you're guilty. So many days later, failure to appear, they're submitting it to the 16th Judicial Court, and that's where she finds herself today, in the circuit court of the 16th Judicial Circuit, Kane County, Illinois, in front of Elizabeth Flood, who's really not a judge because she's a declarant on a frickin' oath of office. Please go look up the definition of declarant. Do yourself a favor. Okay, that's what I got. Got some other ones coming up. I got to reload on what those are going to be. So, have a great day. We'll see you. Bye.